In this video, we'll be discussing important MCQs on Hindu law, Hindu Adoption and Maintenance Act 1956, Hindu Succession Act, Hindu Minority and Guardianship Act 1956. These questions will be very important for LLB students. So let's start. The Hindu Succession Act doesn't have territorial jurisdiction over only Hindus of Jammu and Kashmir, only Hindus to Goa, Daman and Diu, only Hindus of Renocants of Pondicherry, and Hindus of all these areas. Hindu Succession Act doesn't have territorial jurisdiction only to Hindus of Jammu and Kashmir. This is the correct answer. Hindus of only the Hindus of Jammu and Kashmir is the correct answer. If the two persons are related by blood or adoption only through males, each is known to have two other. It is cognate, agnate, full blood or half blood. Related by blood or adoption wholly through males, it should be agnate. Two persons related by blood or adoption wholly through males, it is called agnate. A joint Hindu family does not include married son, married daughter, adopted son or adopted daughter. A joint Hindu family does not include, that is, the married daughter. Daughter married हो गया मतलब she has gone to some other family. So the joint Hindu family will not include married daughters. Hindu Succession Amendment Act 2005 came into effect on 9th of June 2005, 9th August 2005, 9th of July 2005 or 9th September 2005. It came into effect on 9th of September 2005. The Hindu Succession Act as amended in September 2005 empowered the daughter of a copper sinner rights in copper scenery property like son under which section of the act, that is section 6, 7, 12 or 15. It is under section 6. This right has been provided under section 6 of the Hindu Succession Act Amendment Act, which was enacted on 9th of September 2005. This empowered the daughter of a copper sinner in copper scenery property as like son. A Hindu male having undivided interest in a Mitaksara copper scenery property dies leaving behind two sons and one daughter. The daughter is entitled to the following share in the property. Two sons and one daughter. All will have the equal share because by the amendment or Hindu Succession Act Amendment of 2005, this daughter is entitled as like as son is entitled. So 3, it will be 1 by 3. Each will get equal share. Under Hindu law, a karta of the joint family can alienate the property only for legal necessity, only for benefit of state, for both legal necessity and benefit of state, only after obtaining permission from the court. A karta of the joint family can alienate property for both legal necessity and benefit of the state. It is C is the correct answer. Testamentary succession relates to Hindu Succession Act, Indian Succession Act, Guardians and Wards Act or Mohammedan law. It is Hindu Succession Act. Testamentary succession relates to Hindu Succession Act. A property acquired by a female as a copper sinner can be disposed of by her by way of testamentary disposition, gift, both A and B. It is both A and B. It can be disposed by her by way of testamentary disposition or gift. Both A and B is the correct answer. Hindu Succession Act. A Hindu widow X got property in succession from her mother. X dies intestate. She leaves after her a brother and her husband's father and mother. Her property would devolve upon to father of her husband, to her brother, to mother of her husband, to all in similar share. A Hindu widow X got property in succession from her mother, from this mother of X, that is X. She got this property from mother. She lives after her a brother. She is having a brother and her husband's father. This is the, suppose she is the husband's father and husband's mother. Her property would be devolved upon to father of her husband, that is his father, to her brother, that is her brother, or to mother of her husband, that is mother, or to all in similar share. No, this, her property will be devolved upon only to her brother, only to her brother, because this property, she has got this property from her mother. So to her brother is the correct answer. As a result of the changes introduced by the Hindu Succession Amendment Act 2005, the daughter of a copper in a joint Hindu family governed by the Mitaksara law becomes a copper with effect from 1706-1956, 9/9/2005, with effect from 20th of December 2004, or from the day she was born. It is from the date of amendment of the Hindu Succession Act, that is 9th of September 2005. After the Hindu Succession Amendment Act 2005, the daughter of a corporation in a joint Hindu family governed by the Mitaksara law shall have no right in the corporationary property, cannot become a corporationer by birth, shall be entitled to dispose of the entire corporationary property, shall become a corporationer by birth in her own right in the same manner as the son. D is the correct answer. After this Amendment Act of 2005, a daughter shall become a corporationer by birth in her own right in the same manner as the son. This is the correct answer. This should be C and this should be D. D is the correct answer. Under Section 30 of the Hindu Succession Act 1956, a Hindu can dispose of his interest in a Mitaksara corporationary property by will, gift, sale, or none of these. It is by will. Under Section 30 of the Hindu Succession Act, a Hindu can dispose of his interest in the Mitaksara corporationary property by will. Section 30 of Hindu Succession Act 1956 authorizes a Hindu to dispose of by will his self-acquired property, undivided share in the Mitaksara corporationary property, both A and B, only A and not B. It should be both A and B. C is the correct answer. A Hindu dies intestate, leaving behind two sons, one daughter, and widow. His property shall devolve upon sons only, sons and daughter, sons, daughter, and widow, or the widow only. It should be sons, daughter, and the widow. Leaving behind two sons, one daughter, and widow. His property shall devolve upon all of these sons, daughter, and widow. Which one of the following is not a class 1 heir under the Hindu Succession Act 1956? Not a class 1 heir under section under Succession Act, Hindu Succession Act 1956. Father, daughter of a predeceased daughter of a predeceased son, son of a predeceased daughter, both A and B above. It is A. Which one of the following is not a class 1 heir under the Hindu Succession Act? That is the father. Father is not a class 1 heir under the Hindu Succession Act 1956. A is a Hindu male. He dies intestate, leaving a son B, two grandson M and N of deceased son C. B is the son. Two grandson M and N of deceased son C. The three great grandsons X, Y, Z of deceased grandson P. Of three great grandsons X, Y, Z of a deceased grandson P of deceased son D. D is also son. D, then P is grandson, then X, Y, and Z. This is son D. What will be the share of M and Z? What will be the share of M and this Z? See, 1/3, 1/6, 1/6 or 1/9. It should be 1/6 and 1/9. 1/6 for M and 1/9 of for this Z. 1, 2, 3, 4, 5, 6, 1/6, and C. 1, 2, 3, 4, 5, 6, 7, 8, and 9. It is 1/9 for Z. B is the correct answer. The rules regulating the distribution of property among heirs in class 1 of the schedule to the Hindu Succession Act 1956 are contained in section 9, 10, or 11 and section B. It is under section 10 of Hindu Succession Act. The distribution of property among heirs in the class 1 of the schedule is laid down in section 10 of Hindu Succession Act. A mother is not entitled to inherit as a class 1 heir from her adopted son, stepson, illegitimate son, or none of these. It is stepson. A mother is not entitled to inherit as a class 1 heir from her stepson. A Hindu male is survived by an adopted son and after-born natural son and his married daughter. His self-acquired property shall devolve upon all the three equally, only the two sons, only to the natural son, or only to the natural son. It should be all of these three equally. A Hindu male is survived by an adopted son and after-born natural son, suppose B, and his married daughter, that is C. His self-acquired property shall devolve upon all these three equally. Son in class 1 of schedule of the Hindu Succession Act 1956 does not include adopted son, stepson, illegitimate son, and none of these. It should be the stepson. Son in class 1 of the schedule of the Succession Act does not include stepson. A stepmother comes into the category of class 1 here, class 2 here, agnate or cognate. It is coming under class 2 here. Under which section of the Hindu Succession Act 1956 a female Hindu is declared to be full and absolute owner of property possessed by her? Under which section? Section 6, 9, 13, or 14? It is under section 14. It is very important question. Under which section it is declared to be full and absolute owner of the property possessed by her? It is section 14 of the Hindu Succession Act. Under section 14 of the Hindu Succession Act 1956, any property possessed by a female Hindu, whether acquired by her before or after the commencement of this act, shall be held by her as a full owner limited owner, co-owner with their husband, none of this. It should be the full owner. If the deceased leaves behind more than one widow, all the widows together would get one share equal to that of other class 1 heirs. Each widow would get one share equal to that of other class 1 heirs, or none of the widows will get any share, or all the widows will be entitled only to maintenance. If the deceased leaves behind more than one widow, all the widows together would get one share equal to that of other class 1 shares. This is the correct answer. Which of the following is not the heir of class 2 of the Hindu Succession Act 1956? Father, it is in class 2. Father's father, father's mother, it is also in class 2. Mother's father, mother's mother, it is in class 2. Brother and sister by uterine blood. Uterine blood matlab mother is Sam. Uterine blood, that is the mother. Mother is Sam, father is different. Brother and sister by uterine blood, they are not included in class 2 here. That is option D is the correct answer. Which of the following relation is one of the four relations which has been elevated to class 1 heirs category by the Amendment Act of 2005? That is son's daughter's son, daughter's daughter's son, daughter's daughter's son. It is none of the above. Which one of the four relations which have been elevated to class 1 heirs category by the Amendment Act of 2005? It is none of these options. Under the provisions of Hindu Succession Act 1956, any property inherited by a female Hindu from her father or mother shall devolve in absence of any son or daughter of the deceased, including the children of any predeceased son or daughter, upon the heirs referred to in section 15(1) of the Act, upon heirs of deceased female Hindu's father, upon the heirs of deceased female Hindu's husband, or none of these. Any property inherited by a female Hindu from her mother or mother shall devolve in the absence of any son or daughter of the deceased upon the heirs of the deceased female Hindu's father. That is the deceased female Hindu's father. It will devolve upon in their own family, that is upon the heirs of the deceased, that is the wife, Hindu deceased female, and this property will be devolved to his Hindu father upon the heirs of deceased female Hindu fathers. Very simple. A Hindu female, she has got property from her mother or father, and she has died in the absence of any son or daughter. So this property will be devolved to the heirs of her mother and father. Very simple. Upon the heirs of deceased female Hindu's father. Under the Hindu Succession Act 1956, which of the following is not a class 1 heir? Mother, daughter of a predeceased son and father. It is obviously father. Father is not a class 1 heir. Under Hindu Succession Act 1956, which one of the following is not a class 1 heir? Mother, father, son or daughter? We have did it earlier. It is father. It is not class 1 heir. It is class 2 heir. The general rules of succession in case of female Hindus are contained in Section 9 of Hindu Succession Act 10, 14 or 15. It is the Section 15 of the Hindu Succession Act. The general rules of succession in case of female Hindus are contained in Section 15 of the Hindu Succession Act. Section 14 provides the full ownership of this property to a Hindu female, and general rules of succession in case of female Hindus are contained in section 15. The general rules of succession in case of a female Hindu have been laid down in which section of the Hindu Succession Act? It is section 15. Section 15. The property of a Hindu woman dying intestate shall devolve firstly upon heirs of mother, heirs of father, heirs of husband, sons and daughters and the husband. It should be sons and daughters and the husband. In their absence, if no sons or daughters are left behind, and the husband is also not there, then this situation may arise. But when this son and daughter and husband is available, then this shall devolve firstly upon son, daughter and the husband. If a woman who has inherited property from her mother dies without children, then such property devolves on the heirs of her father, the heirs of her maternal grandfather, the heirs of her mother-in-law, on her husband. It is the heirs of her father. A woman who has inherited property from her mother, she has inherited from her mother, dies without any children, then such property devolves on the heirs of her father. These are the correct answer. Which section of the following of the Indian Section Act 1925 treats agnates and cognates and male and female heirs equal? Section 27A, 27B, 33A or 26. Indian Succession Act, that is Indian Succession Act 1925, treats agnates and cognates and male and female heirs equally under section 27 subsection A. That is 27A of Indian Succession Act 1925 treats agnates and cognates and male and female heirs equally. Section 14 of the Hindu Succession Act 1956 applies to movable property, immovable property, both movable and immovable property. None of this. It is both movable and immovable property. It is both immovable and movable properties. It provides full ownership to the female for self-acquired property. Which of the following relation is one of the four relations in which has been elevated to class 1 heirs category by the Amendment Act of 2005? We have done this question earlier. It is none of the above. Sons, daughters, sons already in class 1. Daughters and daughters, son, they are in class 1. Daughters, son, son. Sons, son, they are in class 1. So, none of the above is a correct answer. A dies intestate, leaving behind two sons and wife. A intestate, two sons and wife. The wife was pregnant at the time of A's death. The wife gives birth to a male child after 7 months of death. The child will not inherit any property of A as he was not born at the time of A's death. The child inherits a share in the undivided property that is available for partition on the date of his birth. The child inherits with effect from the date of A's death. The child gets the entire property to the exclusion of his mother and two brothers. It is C. The child inherits with effect from the date of A's death. Is the correct answer. Which law commission report has proposed to amend section 15 of the Hindu Succession Act 1956 in case a female dies intestate, leaving her self-acquired property with no heirs? It is 250th law commission report, 206th or 207th or 208th. It is 207th law commission report. This proposed to amend section 15 of the Hindu Succession Act in case of a family dies intestate. Section 15 provides general rules for devolving of property. General rules of property. That is the 207th Law Commission report has proposed to amend this section. Under which section of the Hindu Succession Act 1956 a female Hindu is declared to be full and absolute owner of property possessed by her? It is under section 14. In which of the following cases the Supreme Court held that there is a good and strong basis for the court to substitute a death sentence by life imprisonment or by a term in excess of 14 years, and further to direct that the convict must not be released from the prison for the rest of his life or for the actual term as specified in the order, as the case may be. Swami Shraddhananda versus State of Karnataka, that is State of Punjab versus Dalbir Singh. Machi Singh versus State of Punjab. The answer should be Swami Shraddhananda versus the State of Karnataka. Supreme Court has held that there is a good and strong basis for the court to substitute a death sentence by life imprisonment or death sentence to substitute it by life imprisonment (LI) or by a term in excess of 14 years, and further to direct that the convict must not be released from the prison for the rest of his life or for the actual term as specified in the order. This is in Swami Shraddhananda versus State of Karnataka. Which of the following statements is incorrect in reference to the Hindu Succession Act 1956? Sister by uterine blood is not included in the schedule. Daughter in here in class 1. Movable property acquired by Hindu female is held by her as full owner. Immovable property acquired by a female Hindu is held up by her as a full owner. Following statement is incorrect. The incorrect statement is daughter in is here in class 1. No, it is. So this is the incorrect in reference to the Hindu Succession Act 1956. Daughter is in class 2. The classical statement of law in which case has been widely accepted as decisive of the standard of care required both of professional men generally and medical practitioners in particular. Bolam versus Frian Hospital Management Committee. R.B. Tolson, R.B. Govinda, or none of these. It is A. Bolam versus Frian Hospital Management Committee. Decisive of the standard of care required both of professional men generally and medical practitioners in particular. Bolam versus Frian Hospital Management Committee. In which of the following cases the Supreme Court issued guidelines for prosecuting medical professionals? It is Suresh Gupta versus NCT Delhi, or Jacob Matthew versus State of Punjab, IMA versus BP Santha, or none of these. It is Jacob Matthew versus State of Punjab. The Supreme Court issued guidelines for prosecuting medical professionals. Jacob Matthew versus State of Punjab. In which of the following cases the Constitution Bench of the Supreme Court has held that MLA is not a public servant within the meaning of Section 21 of the Indian Penal Code? Lalu Yadav versus State of Bihar, Jayalalitha versus State of Tamil Nadu, R.S. Naik versus A.R. Antule, or none of this. It is R.S. Naik versus A.R. Antule. Supreme Court has held that MLA is not a public servant within the meaning of Section 21 of Indian Penal Code. R.S. Naik versus A.R. Antule. In which of the following cases the Supreme Court has held that Chief Ministers of a state is a public servant? M. Karunanidhi versus Union of India, Jai Lalita versus State of Tamil Nadu, R.S. Naik versus A.S. Antule, Lalu Yadav versus State of Bihar. Has held that Chief Ministers of a state is a public servant. It is in the case of M. Karunanidhi versus Union of India. MLA, they are not a public servant. In R.S. Naik versus A.R. Antule, Chief Minister of a state is a public servant. In the case of M. Karunanidhi versus Union of India. In which of the following cases the Supreme Court held that to attract Section 304B, the deceased need not be a legally wedded wife of the accused? Kantilal versus state, Shanti versus state, Kopishetty Subara versus state, or none of these? It is Section 304B. It is Kopishetty Subbarao versus state. Kopishetty Subbarao versus state. In this case, Supreme Court held that to attract Section 304, the deceased need not be legally wedded wife of the accused. It was against the state of Andhra Pradesh. Supreme Court .304 is related to dowry death. Supreme Court held that to attract Section 304B, the deceased, that is the wife, need not to be a legally wedded wife of the accused in case of a dowry death. It is expressed in Kopishetty versus Subara versus the state of Andhra Pradesh. Constitutional validity of Section 309 is upheld by the Supreme Court in which of the following cases? Thomas Master of versus Union of India, Rathinam versus Union of India, or Gyan Kaur versus Union of India. Constitutional validity of Section 309 is upheld by the Supreme Court. That is 309. It is attempt to commit suicide. Attempt to commit suicide is upheld by the Supreme Court in the case of Gyan Kaur versus Union of India. This is attempt to commit suicide. Gyan Kaur versus Union of India. In which of the following cases the Supreme Court approved the doctrine of Parnis party? Gyan Kaur versus Union of India, Rathinam versus Union of India, Arun Shaunbag versus Union of India, or none of these? It is Aruna Shaunbag versus Union of In which of the following cases the Supreme Court has explained the distinction between Section 153A and Section 5052? It is Kedarnath versus State of Bihar, Balwant Singh versus State of Punjab, Bilal Ahmed Khalo versus State, and none of these. It is Bilal Ahmed Khalo versus the state. The distinction between section 153A and section 505 subclause 2. Rule 2 under section 10 of the Hindu Succession Act 1956 is a per capita rule. Per stripes per capita rule of exclusion. It is per capita rule. Rule 2 under section 10 of the Hindu Succession Act is a per capita rule. A Hindu dies intestate, leaving 2 sons, 3 daughters. 2 sons, 3 daughters, 2 widows, and 3 granddaughters by a predeceased son. Calculate the share of the granddaughters. A Hindu dies intestate, leaving 2 sons and 3 daughters. There are 5, and 2 widows. It is 7, and 3 granddaughters by a predeceased son. 3 granddaughters by a predeceased son. 1 son. Calculate the share of granddaughters. It is the granddaughters. But the share of granddaughters. 2 plus 3 is 5. 5 plus 2 is 7. 7 and 3. The answer is 1 by 26 is granddaughter will be getting 1 share upon, that is 1/3. 7 1/3 into 1/3 of 1/7 into 1/3. It will be 1 by 21. This will be the correct answer. The correct answer is C, 1 by 21. Each granddaughter will be getting. Under section 20 of the Hindu Succession Act 1956, the rights of a child born in justo matrimonio have a reference to moment of conception, moment of birth, either A or B, whichever is beneficial to the child. It is moment of conception. The rights of a child born in justo matrimonio have a reference to moment of conception. The provisions of which section of the Hindu Succession Act 1956 deals with presumption in cases of simultaneous deaths? Section 23, 22, 21 or section 20? Is section 21. It deals with presumption in cases of simultaneous deaths. Which of the following cases is considered as locus classicus on section 300 thirdly by the Indian Penal Code? Rudul Shah versus State of Bihar, Birsa Singh versus State of Punjab, Shivaji Shabarao Bobade versus State of Maharashtra, none of these. It is Birsa Singh versus State of Punjab. Locus classicus. It is Birsa Singh versus State of Punjab. Which of the following is a leading case on grave and sudden provocation? It is Nathan versus State of Madras, K.M. Nanavati versus State of Maharashtra. It is Bishwanath versus State. This is a question of IPC, Indian Penal Code, or criminal law. However, the leading case on grave and sudden provocation is K.M. Nanavati versus State of Maharashtra. Yes, KM Nanavati versus State of Maharashtra. Under the Hindu Succession Act 1956, in the case of interstate succession of a male Hindu father is class 1 hair, class 2 hair, special grade hair, or class 3 hair. It is class 2 hair. Father, it is class 2 hair. B is correct. The separate property of a Hindu male dying intestate, that is dying without leaving any will, is succeeded by. The separate property of a Hindu male dying intestate is succeeded by father, mother, brother, or sister. It should be separate. It should be the separate property of a Hindu male dying intestate. It is the mother. Is succeeded by the mother. A Hindu has two wives and one son S by wife, okay, and four sons by wife 2. On a partition of personary property, wife 1 and wife 2 will get no share as neither of them is copersonary. 1/4 share each, 1/5 share each, or 1/8 share each. It is 1. A Hindu has two wives, W1 and W2, and one son by wife 1, one son, and S1, 2, 3, and 4 by wife 2. 4 sons here, one son is here. 4 and 1 is 5, 6, and 7. On a partition of copersonary property, W1, wife 1 and wife 2 will get how much shares? It is 1/8 share each. Why? A Hindu, this is a Hindu having two wives, 1 and 2. 1, 2, 3, 4, 5, 6, 7, and 8. These two wives will be getting 1/8 share each. So D is the correct answer. The Hindu Succession Act 1956 mentions two types of hair of a Hindu male, three types of hair of a Hindu male, four types of a hair of a Hindu male, or five types. It is two types. It is two types of hair of a Hindu male. Mitakshara is written by Bigneshwar, Jimat Bahan, Mitra Mishra, or Kautilya. It is Jimat Bahan. Mitakshara is written by Jimat Bahan. Section 23 and 24 of the Hindu Succession Act 1956 has been omitted by Amendment Act in 1999, 2004, 2005, or 2010. Hindu Succession Act was amended in the year 2005. So, Section 23 and 24 of the Hindu Succession Act has been omitted by the Amendment Act in the year 2005, which was enacted on 9th September of 2005. Which provision of the Hindu Succession Act 1956 disqualifies a Hindu to inherit property of the person whom he is convicted of murder? Disqualifies a Hindu to inherit property of the person whom he is convicted of murder. That is under Section 25. Section 25. The essential ingredients of theft is explained by the Supreme Court in a well-known decision given in the case of Vishwanath versus State of UP, K. and Mehra versus State of Rajasthan, Om Prakash versus State, none of this. It is K. and Mehra versus State of Rajasthan. The essential ingredients of theft. It is a question of criminal law. However, the well-known reason given in the case of K. and Mehra versus State of Rajasthan that the essential ingredients of theft is explained in this case of K and Mehra versus state of Rajasthan. In which section of Hindu Succession Act 1956 the law of Mitakshara has been incorporated? 8, 9, 7 or 6? It is under section 6. The law of Mitakshara has been incorporated. When during partition in a family or it is agreed as family arrangement to maintain the mother, then his contract is void and not enforceable, voidable but enforceable, valid and enforceable, null and void. When during a partition in a family or it is agreed as family arrangement to maintain the mother, then his contract is valid and enforceable. It is valid and enforceable.